Good evening, everyone, and welcome to our Rights at Night for August. While we welcome all public school employees, this event is only for GAE members and GAE staff. Therefore, if you are not a GAE member or part of GAE staff, please sign in by putting your name, personal email address, cell phone number, and school system in the chat in a private message to Lisa Morgan. We appreciate your interest in GAE and hope you will join our organization today by visiting joingae.org. Everyone, please note that you must receive prior permission from the GAE Executive Committee or the GAE Executive Director before recording audio or video of this meeting. Social media posts concerning this meeting shall not contain information about the specific content of the meeting, although the sharing of general information about GAE and GAE events is encouraged. Please be courteous to other attendees and request their permission before posting photographs containing their images. If you have questions about posting social media of GAE events, please contact the GAE Executive Committee or the GAE Executive Director. Again, we are so glad everyone is here today. And for those of you who may not know me, I am Lisa Morgan. I am a kindergarten teacher and the current president of the Georgia Association of Educators. And again, like to welcome all our members to our Rights at Night session for August. Just a moment, I'm going to turn it over to our presenter, Mr. Mike McGonigal, our General Counsel. And as I do so, I would ask you that if you have questions as we go, to please put them in the chat or use the raise your hand feature. But I would remind you that the questions you ask should be general in nature. And if you have a specific question about a specific situation you are experiencing, that is something that you should direct to your UNISERV director, not in this public forum. So thank you all for being here once again. And with that, Mike, I will turn everything over to you.
All right. Thank you, Lisa. I will start my screen share. And let's see. Need to get this out of the way. From the beginning. How's that looking, Lisa?
We need to switch the display again.
oh, there we go. Display. Duplicate slideshow.
No, the top one.
The top
Swap.
one.
Yep.
All right.
There you go.
All right. Very good. Let me. Except I can't see anybody, but that's all right. Well, welcome everybody. Tonight's topic is the Code of Ethics. I assume most people have some familiarity with the Code of Ethics. Hopefully you will come away with some new information and maybe planting some seeds as we evolve and grow in our daily practice as educators. So I know I'm preaching to the choir, but every time I do a presentation, I always promote legal services as a reminder that we encounter potential members every day. And a couple things to keep in mind with GAE's program. One is we have a liability protection that provides insurance coverage in the event that you are sued in a court of law, say, for example, by a parent on behalf of a special needs child, just for an example. You can read the coverage there, the $3 million aggregate. That is more than competitor organizations offer. The same for the $9 million in attorney's fees that it covers. Those are both more than our competitors offer in their liability insurance. But as important and as critical as having the liability insurance, I can count on one hand the number of lawsuits that we come into the GA office every year. The vast bulk of our cases that we come in the door are the employment and certification defense cases. Tonight we're talking about certification defense, the PSC, employment, non-renewal and termination of cases. That's like, over 90% of the work that we do. And the important thing to keep in mind when talking with a potential member is that through NEA, we do not have any predetermined caps on the amount of legal fees or costs that we expend in defense of a member. And that's very important. A competitor organization has caps on what they will spend on defending your career. You don't want to be in a situation where you lose at the school board level and you file an appeal, say, to the State Board of Education, and maybe you lose there, but you are, going to that next level of appeal in the Superior Court, and maybe you lose there, but now you're hitting up against the cap imposed by a competitor organization. We don't have that cap, and we do pursue all meritorious appeals all the way up to the Georgia Court of Appeals and the Georgia Supreme Court. Those cases go way, way over a cap imposed by other organizations. So it's very important, very valuable to keep in mind. The other thing that we do that no other organization does is we file affirmative lawsuits. And that can run the range of First Amendment claims, association, violation of associational rights. It can be race discrimination. It can be violation of FMLA rights. It can be violation of disability rights, or pregnancy discrimination, that sort of thing. Now, when we do an affirmative lawsuit, we have to be very careful and very choosy of the merits of the case, because we're not a personal injury law firm. We don't do this as a standard practice. But getting to the advantage is when I think of filing a suit, I start the meter running in chunks of $25,000, $50,000, $75,000, $100,000. Now that's something that none of us has in our bank account, but through the NEA, our parent organization, we have access to those financial resources that in meritorious cases, we do really go to bat and file lawsuits on behalf of members against school districts. So with that in mind, just a couple of cases that I have been discussing recently. The first one we have is Katie Rinderly, and that's a picture of Katie on the left. And the author of the book that she read to her 5th grade class in Cobb County, My Shadow is Purple. Now, My Shadow is Purple, its main point is understanding difference and welcoming difference in ourselves and differences with our friends and colleagues and coworkers and everything. And it does talk about gender differences, but words like gender ideologies, not in the book. All it's being twisted and manipulated for political purposes in Cobb County. So Katie was noticed up for termination for violating Cobb County's controversial topics policy or divisive concepts policy, that an educator cannot teach something that is divisive or controversial, which leads to a whole bunch of constitutional questions, which we have raised in our federal lawsuit, claiming that Cobb County's divisive concepts policy is so vague, it does not put an educator on advance notice of what they can and can't teach to avoid getting into trouble. So that is point one in the federal lawsuit. We also claim gender discrimination, that Cobb County is enforcing traditional gender stereotypes on its faculty and staff and how they relate instruction in the classroom, virtually erasing, say, gay and homosexual topics in the classroom, even though those are accepted categories under current U.S. constitutional decisions. So that's the federal lawsuit. We've also appealed her termination through the Georgia court system, and her termination appeals is currently pending before the Georgia Court of Appeals, and there will be oral argument tomorrow at 10:30 a.m. In front of the Georgia Court of Appeals. And again, the legal costs in Rinderly's termination and federal lawsuit are in the six figures, and there's just nobody, no other organization has the resources to stand behind its members in these circumstances. So the other case I just touch upon is Green v. Charlton County. That's the quote I take away, is that's the way it is case. Well, the short story is Dr. Sherrilonda Green comes from a long heritage in family that helped build Charlton County. Her ancestors were formerly enslaved people. She comes from a family of educators. She had worked her way up through the ranks in Charlton County, beginning her career as a classroom teacher to assistant principal. And she's currently in a central office position in Charlton County. And they had actually sent her to superintendent training seminars, grooming her to become a superintendent in Charlton County. Well, back in 2017, that position became open. Dr. Green applied for the position. And do you know what? It's not that even she was interviewed and turned down on the merits. She wasn't even granted an interview. Well, that really got our attention in a big way. And that led to a lawsuit under the Open Records Act because they were hiding all kinds of text messages and emails surrounding Dr. Green. Well, we eventually prevailed, and we got the information that we are now using in the federal lawsuit under Title VII, claiming that she had been discriminated against on the basis of her race. Now, that's the way it is. The big takeaway for me in this case is, in the litigation under the Open Records Act, the school board chairman, who's a guy that looks like me, right? His phenotype is European, very light-skinned man, a white male. He was asked the question, so you, Charlton County Schools, have not had a Black superintendent in 134 years since the founding of the Charlton County Public School District. What is your takeaway of that? What do you think of that? And the school board chair said, well, that's the way it is. That's the way it is. We haven't had a Black superintendent. That's the way it is. To me, saying, well, that's evidence, as disgusting as that statement is, that's great evidence of systemic racial discrimination. That's the way it is now, and that's the way it shall always be, in the Deep South. So again, now the fees in her case, again, we're into the six figures, going on several years of litigation, but we're very confident of a successful outcome in her case. No other organization has the resources to stand behind its members, such as Dr. Sherrilonda Green. And last, I just have this great quote from Felania Patton-Dumas, who is a member in DeKalb County. And her story was, and this was written up in our newsletter and in our magazine, so I'm really not violating confidentiality. But over the weekend, a year or two ago, she had a family member, her daughter, come to her house, and she was having some real issues. There was a shouting match, and then it became physical. So Miss Dumas called the police officers. This is at her home in Fayette County. And who do you know do they arrest? Do they arrest Miss Dumas, who is calling for help, or do they arrest the daughter, who was the assaulter in this case? Well, they arrest Miss Dumas. And it was under the Family Violence Act, which is a felony arrest. So she came to us and we said, well, you must disclose the arrest to your principal, which they did. And then the principal sent it to the central office sent it to the Professional Standards Commission, where it sat under investigation. Well, back on the employment side, DeKalb County noticed her to be fired, to be terminated, because she had been arrested for this, which is eventually a bogus, dismissed Family Violence Act arrest. Well, we got her put back to work in DeKalb County, because that is so nonsense. You can't fire somebody after they're arrested. And we got her PSC case dismissed. And it took some doing, but we eventually got it dismissed, because again, how can you sanction a license when somebody's been dismissed? And this is what Miss Dumas graciously wrote about GAE. She's tried other organizations, but they weren't worth the money. And GAE is worth every penny. So I just share that. Keep that in mind when you're talking with potential members. So I think, again, in my presentations, I'm big on some of our history, especially our racial history of GAE. Beginning at the bottom, most of you know we're the product of a merger in 1970 of a Black organization and a white organization. You can see the years that they came together back right after the Civil War. And then we went through this awful period of Jim Crow and during the last century. And then Brown versus Board of Education held that separate but equal is inherently unequal. And the walls of Jim Crow began to come down. Well, 10 years later, the NEA adopted a resolution that all the former Confederate states must merge by July 1st of '66. And as you can see, the merger took a little bit longer here in Georgia, but it did culminate in 1970. Now, one other piece before we get into the code of ethics. I'm just thrilled by discovering this photograph of the GT&EA founder, Richard R. Wright Sr., and the photograph is about 1890-91. So this is Mr. Wright Sr. was born into slavery in Dalton, Georgia, went through the experience of being a chattel slave, and then we had the Civil War, and then the emancipation afterwards. And then in 1878, at that point in time, the Union had began leaving the South, leaving Black citizens virtually unprotected, and so that's why he formed the GT&EA, knowing the importance of education as a gateway for liberation and freedom and equality. And he was the first president of the Georgia State Industrial College for Colored Youth. The other thing about being readmitted into the Union after the Civil War is that all the former Confederate states had to have strong guarantees of public education for all, and they had to have guarantees of land-grant universities. And the Georgia State Industrial College for Colored Youth was Georgia's land-grant university dedicated to African Americans. That eventually became Savannah State, which is Georgia's first HBCU. One other thing, I invite you to Google Mr. Wright's name. After he accomplished those remarkable feats in Georgia, he then goes to Philadelphia and becomes a very successful banker, and organized and founded the country's first Black Bankers Association. And, you know, I say all that, especially now in the, you know, this era we find ourselves in, where the government is, you know, reversing all of the progress that we've made in the area of racial justice, for sure, amongst many other things. Mr. Wright stands as a real inspiration to me, and I'm very thankful that, you know, that without him, I wouldn't be here, and GAE wouldn't be here, for that matter, not certainly in its present form. So I just share that, lift him up as a great success and personal inspiration. I thought, okay, all right, on to the Code of Ethics. So it's important to know that the Code of Ethics that's in place today is effective as of January 1st of last year, 24. And there have been no changes to the Code of Ethics since that date. And the reason I always point that out is that when you're making a decision, career decisions, whether you're looking at a law, statute, rule, regulation, or school board policy, you always want to be sure that you're looking at the most current effective date, because you don't want to make decisions on outdated information, which has happened occasionally over the years, and members will call and I'll be shaking my head, you know, what are you reading? Well, you're actually reading some outdated information, you know, ma'am or sir, so keep that in mind. So this slide just, you know, just refamiliarizes ourselves with who is the PSC. They regulate all manner of certificates and licenses. The important thing to me to notice is that they're political appointees. So those people that write the rules and regulations and enforce the Code of Ethics, that review all of the complaints, they're appointed by the governor. So it's important that we vote, more important that we vote for a governor who's going to be a strong defender of public education and is going to appoint fair and impartial people to the PSC. So here is the breakdown as defined in the statute, the enabling statute, 18 members, and of course, half of the commission come right out of classrooms, including one from a private school, but you can see it's divided up. There must be 2 teachers from K through 5, 2 from middle grades, 2 from the high school, and administrators, boards of education, and including those from the private sector. So the idea behind having 18 members, this cross section of Georgia, they are supposed to come up with standards of performance and a code of ethics that is supposed to represent standards that are generally accepted by educators of this state. And as we go on, we'll see what may have been generally accepted 10 years ago, 20 years ago, has sort of taken a back seat to more pressing issues in contemporary times as society changes, standards change, and the Code of Ethics is no different. It does change and evolve over time, although not in ways that I always approve of, but we'll get into that. So the code defines an educator as, you all that possess a license or that you have applied for a license. And as educators, once you apply and you're signing your name, you're actually swearing and attesting to the truthfulness and honesty to everything that you have, the boxes you've checked and the information that you put on the application. So we have a definition of an educator. It goes on to say, well, who is a student? And it does include students who are enrolled in private schools. And that's interesting in that you may not need a PSC license to teach in a private school, but if you possess that license and you are working in a private school, you are still subject to the code of ethics. And that same logic and reasoning applies to after hours and off-duty conduct. The student is still a student for purposes of the code of ethics, and you are still subject to the code of ethics and as even on your off-duty time. So there are 10 standards, and for the most part, they're very, very broad. I would call them aspirational, except that one of the changes they made about 10 years ago, where you see the word shall, that used to be should. Now that's a true aspirational term. An educator should abide by federal, state, and all the rest statutes. But at one of the meetings, they changed all of the shoulds, all the aspirational language should to shall. And to me, that was a big tonal difference and change in what a code of ethics should be. You know, I have a code of ethics as a lawyer. It's phrased in the aspirational, knowing that we have feet of clay. We're human, we make mistakes, but the people on the commission went from aspirational to command and mandatory language a few years ago. And that's one of my pet peeves. So by the way, but if you haven't told. So another change in the standards in the code of ethics and the way it's being applied today, and it wasn't this way, I would say 5 years ago. And if you think of Miss Felania Dumas being required to report her arrest, today all arrests, excluding minor traffic offenses, are required to be reported to the PSC. I flatly disagree with that, and we can see some reasons why in a minute. But you're basically innocent until proven guilty, and trying to settle or dispose of a criminal case can take months and months, if not years. And this is going to be hanging over your head all that time. And I've got a lot of practical reasons why it's not a good idea. But I've changed my tune. If somebody calls and say, hey, Mike, I was arrested over the weekend for a DUI, do you have to report it? Yeah, yes, you do. Yes, you do. Even though you're not required to disclose a DUI conviction, you have to report the arrest. It doesn't make sense. But when you complete an application for a certificate, you are required to disclose all felony convictions and misdemeanors that involve moral turpitude, misdemeanors involving moral turpitude. And this is the list of crimes of moral turpitude. In the criminal law, they are defined as inherently evil, vile, and wicked crimes of a depraved mind. And you can see that they pretty much are for the most part. But to one little war story that I want to share with you that I wrote about in the No magazine in the fall of 2020, volume 18, issue 3, was a case of a misdemeanor theft by taking of one of our members who was going through a divorce. She, under the family violence program, moved from Georgia to Orlando, Florida, to get away from her abusive, violent ex-husband. And while she's there, she went shopping one day at a Walmart, and she made a bunch of purchases of household items and groceries for her young kids, except that she failed to pay for 2 soft drinks. and she was followed into the parking lot by loss prevention, and she offered to pay for the two soft drinks like anybody would. She was embarrassed and, mortified that, how, I paid for all this other stuff, I'll pay for this. But by that time, the local Orlando police show up. They ask her for an ID. She pulls out her Georgia license, and they said, nope, that doesn't work in Florida because in Florida, if you don't have a Florida ID, we are required to arrest you. Well, from our research, that was a false lie. Our view of it is she was just racially profiled, a single Black female, just getting arrested because she's Black. Well, it gets worse because this happened on a Friday afternoon. So she gets arrested, put in the cruiser, gets processed, but she sits in jail for 3 nights. She hires a lawyer, pays over $1,200, or excuse me, $2,700 for the lawyer. She eventually pled guilty to this misdemeanor shoplifting and paid over $1,200 in court costs and fees. Well, then the other part is, then she comes to, her husband discovers where she is in Orlando. So she hightails it up to a safe house here in Georgia. And it's not far from here. It's a safe house in Decatur, city of Decatur. And she reapplies for her Georgia license, but she doesn't know that based on the wording of the application, that she had a misdemeanor involving moral turpitude back in Florida, and she didn't disclose that, and she came to us for help. We relayed this story of racial profiling in everything that she had been through, for being arrested for $2.37 of soft drinks. The PSC, our position on her behalf fell on deaf ears, and they came back with a 20-day suspension of her license. Well, 20 days of her work days adds up to $6,828.60 based on a $2.37 soft drink where she pled, yeah, I did it, she did the right thing, and all the rest of it. Well, long story short, that's just to show you just how very serious the PSC takes these failing to disclose crimes. In my view, they just simply overreact. The punishment does not fit the crime. But for those who are, listening and others, if you ever have any questions, you're not sure how to answer a question on the application, call us here in Legal Services, and we will definitely be able to help you out. And the good part, the ending of the story, is we were able to avoid any suspension of this educator's license, and we took a very light wrist slap, and she's back at work educating children. So these are the crimes that you do not have to disclose on the application. And you see that second one right there, driving under the influence. If you have a conviction driving under the influence, you don't have to disclose it. But remember what I said earlier, even if you're arrested, you must report the arrest to the PSC. So that's like, to me, pounding a square peg in a round hole. It's not logically consistent, but that's the way the law is today. Are there any questions, Lisa, in the chat so far or not?
No.
All right. So moving on, standard 2. Here it is again. An educator shall, that's mandatory, always maintain a professional relationship both inside and outside the classroom. I call these, common sense boundary issues. But there's a list of unethical conduct after standard 2. And you can see it's just all the really, evil, vile, wicked things that, that none of us are going to do. We're not going to engage in child abuse or have sexual relationships with our students. We're not going to harass them and those sorts of things. We're not going to be doing any of those things. I wanted to just spend a moment on, you get lots of training on your duties as mandated child abuse and neglect reporters. Just a couple tips that I'm sure you're aware of, but the law requires reporting within 24 hours, and there is no wiggle room, no valid defense. Courts strictly construe that 24-hour requirement because we're there to protect and guard the health, safety, and welfare of the students, of our children, our future. So extremely important. So a real case comes in where a child comes up to me on a Friday afternoon and says, "Young lady, my uncle touched me inappropriately, a few weeks ago at a family picnic in South Carolina." And but it's late on a Friday. Everybody's gone home. You can't find an administrator. And so you decide that it can wait till Monday. Well, no, it can't. The fallback positions are, if you can't find a school level administrator, call the central office. You should have your principal's cell phone number, so it really is not that impossible. And then last but not least, if you cannot get any school district official, call local law enforcement, call 911 and tell them exactly what your situation is. And they'll send an officer over. We'll get through this, but don't delay till Monday. And of course, in that situation, the educator lost her job and her license for failing to report within 24 hours. It's a very sad situation. Another situation is that you are to report but not investigate. And I've had a couple of cases come in where after the fact, where again a young child comes to me and says, "I was touched inappropriately by my uncle at a picnic." But it just so happens that a family member works at the school. A grandma or an auntie works at the school, and you think, I know this girl's got an imagination. I'm going to go talk to the grandma or the auntie and ask her about what she told me. Is she credible on this? Well, again, you absolutely cannot do that, because when you're talking to the family member, they might know what's going on and don't want anybody in the world to know about it, or are just going to, brush it off as an imaginative child. But under no circumstances are you authorized to investigate what the child has told you. You are just report it immediately and in writing. Remember, document that you are making that report. That is good insurance. So just a couple of quick tips about social media. Can school employees be disciplined or discharged for off-duty social media activities? And a lawyer's answer is going to be maybe. Pretty rare, but we always look at it on a case-by-case basis, always. But the strongest protections you have as public employees are to the extent that, one, you speak as a private citizen on matters of public concern. Those are the two main analytical tools that lawyers look at when one of our members, is looking for legal advice and guidance on First Amendment speech. And so when you think about it, when you're at school, you're working as a public employee. It's very, very difficult, and I don't have an example of where you're at school, but you're acting as a private citizen. So it's extremely rarely happens. And then it also has to be, your speech has to be on a matter of public concern. And I do recall a federal court case of not a GAE member who was terminated or maybe non-renewed in Jefferson City years ago. And after she gets terminated from her job, she and her lawyer filed a First Amendment claim saying that when she met with the principal about her evaluation, that she was speaking as a public citizen, and that she literally tore up her evaluation and slammed it on the desk. And they were trying to contend that that was on a matter of public concern, saying a lot of teachers in the school system are treated in the same way. That argument didn't fly, as you can only imagine. It didn't fly. Here's an example, a 2017, 2018 example of a teacher's off-duty Facebook post regarding Black Lives Matter. And now I won't repeat what she wrote, but it was highly racist, inflammatory, shameful language to describe the Black Lives Matter marchers. They weren't protesting, they were just holding signs, walking in this parade. Well, so under this test, backing up, she was speaking as a private citizen. She was speaking on a matter of public concern. It's not a view that I share, but speaking out about Black Lives Matter is a matter of public concern. But another part of this test that courts look at is, did it, even if you spoke as a private citizen on a matter of public concern, did it disrupt the workplace? And in Tift County, you can imagine the African-American community was in an uproar. Let the superintendent know, this Miss Tucker, something's got to happen. She's describing these marchers in highly inflammatory racist terms, frightening the children, the students of Tift County schools. So after she gets what I call a pretty minimal 5-day suspension and diversity training, she found some lawyers and filed a First Amendment lawsuit. Again, she lost mainly because the court said it caused a huge disruption in the school system. So it's a good case. You can copy and paste if you're able to, or take a camera shot and look that case up, and you can see what she wrote. It's highly offensive. And so the court made the right decision. Standard 3. Okay, so an educator, I don't have the word shall, but shall refrain from the use of alcohol or illegal unauthorized drugs in the course of professional practice. That's very broad. And then after that standard, there's some unethical conduct includes being, on school premises or a school-related activity like a field trip, using, possessing, consuming alcohol or unauthorized drugs. And the interesting thing is, even if students aren't present, now that could mean you're at a basketball camp or a football camp and you're there as one of the coaches and you're drinking alcohol in your room with other adults, but you're on a trip with students. So if it gets found out that you're drinking at the basketball camp or football camp in the room while the students are asleep, that's a violation of the code of ethics. And this was put in there a number of years ago when in Douglas County, just before school was opening, the faculty and staff at one of the schools in Douglas County were setting up their rooms. There was no air conditioning, and some of the staff brought coolers of alcoholic beverages, mainly beer and wine coolers and things. No students present, but things got a little bit out of control where they decided to go play a game in the gymnasium that I'd never heard of before, but Scouts Honor, they played a game called strip basketball. And that got leaked out into the community and into the local newspaper. And of course, that splashed across the headlines there. And at the time, the chief of the ethics division at the PSC lived in Douglasville. So he persuaded the commission, and there's merit to the idea that you shouldn't even have alcohol on the premises or on a field trip, even if there aren't students, because we are, representatives of, we want to have good relationship with the community and the taxpayers. So a real quick scenario, if you're an educator acting as a parent chaperone on a class drama trip to the Fox Theater, and you go to a restaurant and you consume some wine at the restaurant, with students present, yes, that would be a violation of the code of ethics. That's pretty straightforward. And then the other situation is, it's Friday afternoon and you're going to a local restaurant and your principal is buying drinks for people, right? And everybody has a couple rounds of some alcoholic beverages. No students are present, but people are beginning to feel a little tipsy, that sort of thing. That as long as there's no students present, then that's not a violation of the code of ethics. So standard 4 is just one word, honesty. You shall exemplify honesty and integrity in the course of professional practice. What does that mean? Well, the code then lists examples of unethical conduct. And you can see misrepresenting your criminal history, as we talked about the application process, information submitted to the government. That can be in the form of grants. And once you write a grant and you get the money, you have to account for how you're spending that money in accordance with the terms and conditions of the grant. We had a member years ago, an administrator member, get a grant for some capital improvements at her school, but she spent the entire grant money putting brand new hardwood floors in her office and buying new furniture for her office and bookcases. And the school district, looked at that a little bit sideways and said, you misspent the money. And yep, sure enough, we went through the hearing process and unfortunately did not prevail in that situation, but that would have been a violation of standard 4. But a little bit more common in my work is reasons for absences. And I guess what I'm getting at there, if you're calling in sick, please be truly sick. Don't go shopping, don't go on a cruise, don't go on a quick trip to, wherever, Las Vegas or whatever, because these days you have these, camera phones handy. And yeah, people can, take a photograph of you, put it on their Facebook page and, real innocently do that, but then expose you to exposure for falsifying a reason for being out on sick leave when you really weren't sick. And those Those happen more frequently than you can imagine, but it's the ubiquity of these days of camera phones. So just word to the wise. Here are some other examples. You can't forge a signature on an SST record or on the IEP forms. And I know in special education, there's always a lot of paperwork to do, and people have time crunches and time deadlines to get IEPs done, by a certain date, a certain deadline, close of business Friday. And there's been situations where everybody on the IEP team is in agreement that it should be modified, but I can't get everybody's literal signature on the IEP form itself. So I will, under the time pressure, and I don't want to get in trouble with administration, I'll sign other people's names to the IEP. And again, that's just a very bad idea. That's a strict liability. I'm going to call it a crime, but a strict liability law that again, there's no real defense. That even if I were to come and testify on behalf of my colleague that I agreed with that modification. I did. We had a conversation. But then I'm going to be asked, did you get permission to sign your name? No, I didn't. Is that your signature? No, it's not. And, the whole case is going to just simply turn on a few questions like that. Falsifying time records is a good example of what we can do for our classified employees who are paid under the Fair Labor Standards Act, entitling them to minimum wage and overtime. Okay. So in many of those instances, our classified employees clock in and clock out. So we have to keep track of their hours pretty closely. Well, in this situation, a paraprofessional was told by her principal that when she was going to eat her lunch, that would be on her own time. So he was telling her to clock out. And then he told her, but you go eat your lunch in the cafeteria where all the students are. And then after your lunch, you're finished with your lunch, come clock back in. Well, he's trying to pull the wool over her eyes, because even though he was telling her to clock out, trying to fool her into believing that's not compensable time, it really is, because even though she clocked out, he is directing her to perform work. What is the work? Well, you're directing her to eat lunch in the cafeteria where what is she doing? Eating her lunch and supervising the students in the lunchroom. And that was a clear violation of federal law. So we got unfortunately, principal was in trouble. We stopped the practice and got the paraprofessional her back pay. But that's a good example of what we can do for our classified members under federal wage and hour law. Standard 5. Since we're public employees, everything we do is more or less entrusted with public funds and property, like our classroom, our laptops. It has to be done with a high degree of honesty and accuracy and responsibility. So the tips here are, if you're asked to be like a club sponsor or a booster and you're uncomfortable with it, you can decline. But if they say, no, we really, you have to do this, you're uncomfortable, request training in how to handle money, and make sure you get that training on handling money, what's coming in and what's outgoing and that sort of thing. And don't let a booster club give you a debit card, because that's asking for disaster. Debit cards, you can go into a big box store and make a purchase for the booster club, whatever that might be. But if you don't have that receipt, then you're going to be held liable for failing to account and substantiate that legitimate expense for the booster club. So some booster clubs offer those debit cards. Turn them down. Just stay away from it. That's just bad news. Another strict liability crime would be number 4, commingling. For whatever reasons, whether you have good intent or a bad intent, but if you're taking in the booster club money and you put it into your personal account, that's, right there, that's a strict liability crime. Even though you had an intent to put it back in the booster club account, if you're caught commingling, we're just dead in the water. There's not hardly a valid defense, because the law and the courts look at that as strict liability. They're not looking at your subjective intent. They're just looking at the act itself. Remunerative conduct, standard 6. This is a conflict of interest standard. You shall maintain integrity when accepting gifts, gratuities, and favors, and additional compensation. And we'll see in a moment, there's that general prohibition, but there's a gigantic loophole that says you can, if you get approval by the superintendent. And here is the list of unethical conduct. And as you go down the list, you can see what's prohibited, but pretty much every one has a loophole unless it's approved by the school board. Now, some districts have policies that say gifts up to $100, it's okay. That's not a conflict of interest. So if you get a gift card from Publix, Kroger at the holiday time for $50 or something from a parent, that's okay. That's not a conflict of interest. But if it's around milestones, testing time, and the parent hands you the keys to a Mercedes or a Lexus or something, that would pose a real problem. That would raise some eyebrows. Now, wouldn't it? I had a question the other day about tutoring students at school in exchange for cash money. To me, that's a violation of the Code of Ethics, because you're using the public school, the public property, to run a private business out of, and that's just a no-no. And that was just a hypothetical. Nobody was actually doing that, but the question was raised as an educational tool to remind people not to be running a business like Amway used to be big. You can't run a private business out of the school because it's public. So standard 7, moving on, getting close to the end. An educator shall comply state and federal laws relating to the confidentiality of student records, personnel records, and standardized test materials. Now, under this particular standard, this used to be a huge volume of cases in terms of violations of standardized testing protocols and administration. And when I started a few years ago, when Governor Barnes was the governor, he began that whole era of accountability, what's called accountability, which meant, standardized testing. Every time you turned around, there was another standardized test. And at the beginning of that accountability era, quite frankly, nobody knew what was up, what was down. And I had situations of members, getting caught up where the administration would hand out ITBS test books, and for those who remember the ITBS, 2 weeks before the test was going to be administered. Well, that's just, a little bit too, that's not kosher. So in a few situations, the educators would just feel under pressure to increase test scores, which is a legitimate, anxiety and a legitimate job expectation, but they went a little far and opened up the testing booklet and looked at some of the questions. And in some instances, it had been on material that had not been taught up to that point in the year. So they would jump ahead and teach material out of sequence so that the students would test well on the test. So if you're teaching content known to be on the test, that is a violation, obviously, of the Code of Ethics. Standard 8 is amended your required reports. There's a couple of areas you're required to report a breach of the Code of Ethics. You're required to report child abuse and other required reports, and we'll see what those might be. And you to report them through the local chain of command, or you can go straight to the Professional Standards Commission. Now, when it comes to reporting violations of the Code of Ethics, you'll see in paragraph 2, you're required to report violations of the code of which you have personal knowledge. To me, that means I'm a firsthand witness of, Mr. Mike grabbing and shaking a student by the shoulders violently. Okay, I have to report, I have firsthand knowledge. But what if I hear about that same scenario in the faculty lounge? I saw, Mike grabbing the student by the shoulders and shaking him, scaring the child. If I don't have firsthand knowledge, then I would say you're not, strictly speaking, required to report that. But I know from experience, and if I heard something like that, even though I didn't see it firsthand, I would report that. Again, even though it's not firsthand, we're there to protect students, and what you overheard, you probably can't sleep at night. You probably know that student, you know them well, you know their parents, and maybe you know Mike, and maybe Mike does have an anger issue too. It's better to report it and get the monkey off your back and put it in writing. Always document that you're reporting these things. Document is a good CYA insurance policy. Standard 9, again, very, very general. An educator shall demonstrate conduct that follows the generally recognized professional standards. And then it has this even more broad language, preserving dignity and integrity, excuse me, of the profession. Now, what that means, real importantly, a few years ago, they reconfigured the Code of Ethics in 2017-18. They eliminated Standard 8, which was really about abandonment of contract, and they incorporated that into new Standard 9. And this is what the important part of Standard 9. Unethical conduct under Standard 9 is a resignation that would equate to a breach of contract. And then they have a definition of what is a breach of contract. Very important to become familiar with this. A breach of contract occurs when an educator, 1, fails to honor a signed contract for employment with a school system by 2, resigning in a manner that does not meet the guidelines established by the PSC. Well, you can access the guidelines, as I put at the bottom, and I suggest everybody go there and print out a copy of the guidelines for breach of contract for the Code of Ethics and become familiar with those. Some important things, though, to note. A breach of contract boils down to the distinction between a resignation or a release. Now, there is a magic date in the law, 20-2-211B, and the PSC adopts this definition in their breach of contract guidelines, saying that they will not sanction you if you resign prior to June 1st. So if I sign my 25-26 25, 26, no, 26, 27 contract. I'm looking ahead. I signed that in February, March. I return it, it's accepted. I still have till June 1 to resign without penalty, okay? And that's universally adhered to by every district that we've encountered, myself or our UNISERV directors across the state. After June 1, though, it becomes much more difficult to get that release, because the common problem is they would say, sure, Mike, we'll release you, but not until we find a suitable replacement. How long can they hold me to that contract? As long as they want to. And the closer you get to the start of a school year, the harder and harder and harder it's going to be to release me without that suitable replacement. And most, administrators aren't going to don't want to go on a job search, finding replacements. But I tell you, we've had a couple of calls recently, very serious, involving very difficult divorces involving female members going through a difficult divorce, and they have violent, abusive husbands. And these are very, very tough conversations to listen to. But in these situations, they've gone to administration and explained the difficulty that they really do have to pick up and leave because their husband's been arrested. He's violent. He's been threatening me. And so I got to move like quick because it's a matter of life or death. And thank God the administration, complied. It's not going to say we got to find a suitable replacement, but they let these two ladies out of their contract. The other thing to keep in mind is does the accepting district accept a resignation, which is a unilateral act? I'm just resigning and I'm leaving. Will the accepting district take that unilateral resignation, or do they insist on a release? And almost universally, they're going to require a release these days. And so our last standard is all about standardized testing. You can read, it's very short. When this rule was proposed a number of years ago, that one sentence was actually 4-page single-space standards. And so me and other people raised a ruckus, and it made sense. You don't want to have 4 pages of single type, words in the code of ethics. It's got to be something like this. And then their unethical acts is, again, very brief, but it relies upon school districts to make sure that you have professional training and professional development on what is proper test security and how do you maintain the integrity of standardized testing and testing materials. And this is our to-do list that I've used for a long, long time. This is the standardized testing do list. And these are the things that you do on a daily basis that are, that are good, that are prepping the kids on how to take the test, right? And that's what you all are pretty much doing on a daily basis. What you can't do if the testing don't list, like I hit on earlier, teaching the test, or teaching to the test, or teaching test items or content known to be on the test. And again, this used to be a huge part of my own caseload back in the, back around to 2000, say to 2010 era or so. Don't see these anymore because school systems have finally gotten up to speed in educating educators how to properly administer a test. Back in the day, I've had more than one case of the educator during a standardized test walking up and down the aisles, making sure that the students were on task and they weren't falling behind. And on some occasions, the educator would tap on the desk, trying to get the student attention to get them on task. Well, that would get misinterpreted in, Mike was pointing to the right answer on the test. Just things like that. Just, I could go on with other war stories, but we don't see these anymore because there's fewer standardized tests, thank God, and districts have gotten a lot better in their protocols and procedures in administering standardized tests. So this is just a basic thumbnail that is followed. Any adult in Georgia over 18 can file a complaint. That means parents. It can mean former students as well. The complaint goes to the commission to determine whether or not to investigate. They look at, is there probable cause to investigate? If there's no probable cause, they dismiss it. If there is probable cause, then you have a right to appeal to this ALJ, administrative law judge hearing. Or you can enter into a consent order agreeing to the recommended sanction. But we're always advocating, appeal, because you have much more fairness and much more due process in front of an administrative law judge who is removed from local school district policies, okay? We have a much better chance at defeating the allegations at a hearing. And in some cases, this is something it's interesting, like that 20-day suspension for the $2.37 soda. We appealed that, and eventually when the Assistant Attorney General got the case and read about the case, they said, oh, no, this is a loser of a case. The commission never should have recommended a 20-day suspension, and we're able to just simply to dispose of it with a minor slap on the wrist. So the educator didn't lose any money. But sometimes the lawyers at the AJC, Attorney General's office, who represent the PSC in these cases, they're a lot more calm and rational and level-headed. And when they see the PSC as a body making mistakes where they see the punishment doesn't fit the crime, they'll be our advocate back at the commission so we can settle these cases fairly. And if we lose at the ALJ, we go into the court system, which can mean going up to the Georgia Court of Appeals and Georgia Supreme Court. And again, that's going to blow the cap on the legal fees that other organizations have on the amount that they expend in defense of a member. And your license is worth more than the $20,000 cap that other organizations have on what they will spend in defense of your certification and your career. We don't, and we do pursue appeals like we're showing in the Katie Rinderly case. We're in front of the Georgia Court of Appeals. Other organizations don't do that. They don't have the resources that you do as members of GAE NEA. Well, with that, that's the end of the presentation. We're there to support you. We're stronger together. And I want to thank you all for attending, and I hope you learned something new tonight.
Thank you, Mike. We didn't have any questions in the chat, so I will thank you. Thank everyone for attending this evening, and everyone have a great evening.